I hit record, so whenever you're ready to start.
Oh, okay. This is, okay. Just roll?
Yeah, whenever you're ready.
Okay. Good morning, everyone, although this is going to be less of an everyone because the audience is a little bit restricted on this. The audience here is intended for residents of Lansdowne Woods in Leesburg, Virginia. And the purpose of the video has to do with the repercussions of the ongoing lawsuit. So, what I will not be doing in this video is talking about either of the parties to the lawsuit, you probably know that, or any of the issues of the lawsuit, you probably know that. But the parties are represented by capable legal counsel, and it will go through the process however the people wish to go through the process. But there are implications, significant implications, for the residents of Lansdowne Woods, of which I am one. So, for a little bit of background, many of you know me, but for those of you who do not, my name is Andy Norton. I am with Sampson Properties. I am a real estate agent that both lives and works in Lansdowne Woods. I've lived there for 15 years as an owner. So as I describe the implications here, it's going to apply to me as well as it will apply to you as well. And so, by way of a little bit of background, yeah, I've been doing real estate an awfully long time, over 4 decades, and I was fairly certain about the implications of this suit on the residents, but I've been wrong before. People who know me will say, I'll be wrong again, but I didn't think I was. So I checked what I'm about to share with you with a real estate settlement attorney, with different mortgage loan officers. One mortgage lender who does reverse mortgages, another mortgage lender that does conventional mortgages, with other real estate peers. And so what I'm about to tell you, I have a very, very, very high confidence level is so. And you might want to stay with me towards the end of this. Some of it is intuitive, but some of it not. So let's start with a definition. And one is called a non-warrantable mortgage, something many of you may not have heard of, and I'll say this one again, non-warrantable mortgage. As soon as this lawsuit was filed, it became something that had to be disclosed legally. And is being disclosed legally. And you might say, well, disclosed to whom? It's being disclosed to buyers. It's being disclosed also to buyers' lenders if the buyer is getting a mortgage. And on a non-warrantable mortgage, when a loan mortgage is being approved, or what they say, underwritten, when the lender sees this lawsuit disclosure, which by the way happens in the HOA documents in Appendix 13, which is where it should be. On Appendix 13, there's a checkbox, yes, no, and if it's yes for a lawsuit, there is a description, as there should be, of the lawsuit. And so that disclosure is being made, yes, by state law, and it's being made on behalf of the seller to the buyer, but also to the buyer's lender. And when the lender sees a lawsuit like this, from what I've been told, and also from what I kind of knew from my training going into this, it makes the mortgage automatically rejected. And so this would be true of a conventional mortgage, a VA mortgage, an FHA mortgage, a mortgage that's being sold to Fannie Mae, perhaps, a mortgage that might be sold to Freddie Mac, perhaps. For those of you who don't know, Fannie Mae and Freddie Mac are what's called GSEs, for government-sponsored entities. And the reason that these loans would be rejected has to do with regulations that came about with the passage of the Dodd-Frank Act in 2010 as a result of the great financial crisis in 2008. And the purpose of the act and the regulations that flowed from that were to protect consumers, yes, but also to protect the taxpayer, because often when a loan that really shouldn't be made is made, depending on how badly things go south, it could be the taxpayer who has to take the hit on this. So that lenders are not just being arbitrary in saying, I see this lawsuit here in Lansdowne Woods, I'll reject it. No, they have regulations that they need to follow, and that process has begun. So the lawsuit itself was filed, I believe, June 2, relatively recently. And one of my sales, I saw the disclosure package, and that's how I know it's Appendix 13. And I have to say that management described it, as far as I could tell, perfectly well, responsibly, and fulfilling the obligations of state law. And for that matter, once these documents are prepared on behalf of the seller has to pay for these, and then they sort of flow downstream to the buyer and also to the buyer's lender. We're about to see a series of dominoes that will be starting to fall. And I'll actually go out on a limb here and say that for Lansdowne Woods residents, owners, you, myself, this is a Houston, we have a problem moment with various repercussions that you'll see in a moment. A buyer can be buying essentially one of two ways, with a mortgage or without. And if it's without, they're probably buying all cash. But as you're about to see, there's no real workaround here yet. Now, I have to say, before starting this video, I am working with a mortgage lender on a possible workaround. But it doesn't look like there's going to be a plan B. This is something where, as owners, everyone's going to have to kind of feel their way. With respect to how this shakes out, a buyer typically has their own agent, and a seller typically has their own agent. And the seller's burden of disclosure of this lawsuit to the buyer, that burden of disclosure is fulfilled with the condominium documents, because under Virginia law and in the standard contracts, it does say that the seller will provide disclosure of HOA docs and condo docs. Remember, in Lansdowne Woods, we have both HOA and condo, from the seller to the buyer. So that burden of disclosure on the seller part, that's done routinely administratively. The next question is kind of what happens from there. Some people are saying that the listing agent, the seller's agent, has some sort of an overarching moral responsibility to tell the buyer and the buyer's agent, look in Appendix 13. And as I have discussed this with both real estate attorneys and other agents, I really don't think that's so. And what I'd like you to do in the audience here is put yourself in the chair of somebody selling. And you're hiring a real estate agent to represent you and to get you to the settlement table. And there are laws that govern your realtor and what they do in order to get you to that objective so that you can sell and get your money and go on with your life. If your agent goes above and beyond what the law is requiring them to do, with some sort of additional moral compass, put it that way, you can make an argument, oh, there's a higher burden of disclosure, but that's not what the law says. And if your agent goes above and beyond what the law says, and it ends up costing you your sale, and you cannot get your money, and you cannot get on with your life, and you cannot go where you're going, that agent is really breaching their duties. So as far as the seller's agent, the listing agent, they're going to be playing it by the book on following law. Then the other interesting question becomes, well, what about the buyer's agent? What about the buyer? The ultimate responsibility with respect to the disclosure documents, includes the lawsuit here, the ultimate responsibility is for the buyer to read their own disclosure docs. But if you kind of remember when you bought, unless you're a retired CPA or retired an attorney, and maybe even then, most buyers don't read through all of their disclosure docs. I mean, you remember, it's a ton. It's a lot of paperwork, whether it's in physical paper or PDF. It's a lot to read through. So most buyers don't. Where there's a burden here that I don't think is going to be initially met, and this is going to cause some conflict. Most buyers' agents do not read the disclosure documents, and if they do, it's sort of like skimming them. And this can be pretty dangerous in this situation for a buyer's agent, because the buyer's agent is going to have a burden of telling their buyer client, take a look at Appendix 13. Did you see that? And do you as a buyer want to undertake the risk of this lawsuit and proceed with the transaction? And during the receipt and review period that a buyer will have, they will be able to void the contract without penalty and get their deposit back, irrespective of what the lender is doing. So the first bite at the apple, so to speak, of rejecting the contract and walking away from the transaction will really be during the disclosure document review period. But even if the buyer says, okay, I'm willing to proceed, it will then go to the lender and will almost certainly be rejected by the lender. And so I'm going to divide the real estate agent community that services Lansdowne Woods into two groups for purposes of this video. And as recently as coffee, about an hour ago, with other of my neighbors, they didn't feel this was a fair characterization, but I think it is. So for purposes of the video, bear with me. There are two groups of agents who work in our community. Those who, like me and a few others, work there a lot. And we know about the lawsuit, we know about the implications, and whether we're working with a buyer or a seller, we are advising our clients appropriately with a higher level of knowledge that we've got. But the other group of agents who are out there don't know what a non-warrantable mortgage is, let alone know how to guide their client around the rapids, so to speak, of a non-warrantable mortgage. So there are agents out there who will be doing business in our community for a while who are going to be blindsided by the non-warrantable mortgage issue, by the rejection of the mortgages by the lenders. They'll be blindsided. And my opinion is that if an agent is not making themselves aware of the environment in which they function, they are not serving their client. But I'll tell you, they're out there. And because I and other agents have spoken to them and actually said, hey, do you know about the lawsuit? And they look blankly like deer in the headlights. What? So that's going to be an issue that the community faces too. Does it make a difference, now more than ever before, who a buyer or a seller hires to represent them as a realtor? And the answer is, with the background of this lawsuit, this is Lansdowne Woods, Houston, we have a problem moment. Now, I did say at the start of this that there were two scenarios here. What happens if there's a mortgage? And I've addressed that. Highly, to the degree of near certainty, the mortgage is rejected. But you might ask, what if it is an all-cash deal? Then what? And it is somewhat less complicated because there's no lender to reject this. But the buyer can reject it. And some of this now is going to depend on the dynamic between the buyer's agent and the buyer. Because it is going to be the responsibility of the buyer's agent to tell the buyer, hey buyer, take a look at Appendix 13. Do you want to proceed with this? Do you want to undertake the risk of this? Yes or no? If you do, it's on you, but I'm letting you know that there is a $4.5 million lawsuit hanging on here. You can go ahead or not. That's your choice. And what I'll submit to you in this video is that if that buyer's agent basically has that conversation with the buyer, there are going to be a lot of buyers who say, wait a second, this is not what I signed on for. There is, I don't know if I want to invoke Mike Tyson, but it's an apt description for this video. And that is, everybody has a plan until they get punched in the nose. And for many buyers and buyers' agents, the existence of the lawsuit and whether or not to proceed is going to be the proverbial punch in the nose. And I think that a lot of buyers are going to say no. For the foreseeable future, while this lawsuit plays out, however it plays out, there will be more units that don't sell than not. So, what is a seller to do? There are a number of options, and I won't say that any of them might be necessarily palatable to a given seller, and they should definitely discuss this with a financial advisor or with adult children or whomever. One is obviously stay put. Do not sell, don't put it on the market. Stay put and wait for the situation to quote unquote normalize, whatever normalize looks like whenever this resolves. And that's all well and good unless as a seller you have to sell. And I'm going to give you an interesting example because you know this is common in our community. Suppose a seller is going from Lansdowne Woods to assisted living, and either the seller and or the family need the money from the sale of the condo to pay for assisted living. Staying put is not going to be an easy option. It may not even be a possible option for many, many families. But it's an option, and I'll put it out there. Another thing that people could do is to rent their condo rather than sell it. And there are some advantages to that because the rental market at the moment is very, very tight. As of this taping, there are no condos in our entire community, over 1,100 condos, not one that is available for rent. So if people need to do something to move on, they might decide to rent. Another option, this is exceedingly rare, but not unheard of, is to provide owner financing for the purchaser. And that you could do. Depending on the buyer that you've got, and I'm going to use this as a hypothetical, the numbers could change, would change. But if a condo were selling for $400,000 and a buyer was going to be putting down $200,000 and getting a $200,000 mortgage, a seller could say, I will finance $200,000 for you for 2 years, and as a buyer you agree that when this lawsuit resolves, however it resolves, you'll get your mortgage and go to closing. That is something that an owner could do. There is a possibility, and I alluded to this earlier, that there could be a workaround with different mortgage lenders who, for a higher interest rate and for a larger cash down payment might, and I will say might, agree to do a mortgage. But at this point, as of 5 o'clock last evening, I was being told no, that the lender's appetite for risk, this kind of risk hanging in the background, a $4.5 million lawsuit, they did not want to take a bite of that apple, even with a higher rate and even with more cash down. One of the things to look into the future at, suppose, for example, that you do rent. Or suppose, for example, that there's a whole lot of supposes. But when this resolves, there are going to be a lot of transactions that would have happened in a regular, orderly way in the course of a year that don't happen. And when it resolves, a lot of these condos are going to come onto the market as essentially the same time, essentially flooding the market with an inventory. And that will depress prices significantly for a while. Now, a while is not forever, but we're in an active adult community with a median age in the 70s. Most of us don't have forever to wait for a market that may normalize. So we have significant implications that are going to flow through here, regardless of the how and the when this resolves. Remember, I'm saying resolves, not settles, because we don't know how this will resolve. But that the longer it drags on, the more transactions that would have taken place in an orderly way will not be taking place, which means that when it resolves and these transactions do start to take place, I submit to you it's going to be in a disorderly way, flooding the market with inventory and depressing prices for a period of time. There are some other interesting affected parties here. And I'm not going to assume that everybody in a management position in our community knows the following yet. Now they might, but I think that a bunch of them maybe not. So if you stop and think of it, when a buyer goes to closing, among the fees that that buyer pays in closing costs are what are called capital contributions. And some of the capital contributions go to Lansdowne Woods as an HOA, and some of the capital contributions go to the individual condominiums that make up our community. And I have been told reliably, although I'm a bit skeptical, we shall see, that the amount of the capital contributions that flow into our individual condominium buildings is not, quote unquote, significant. And I think that the people who are saying it's not significant are not the people who are relying on those reserves who manage our buildings. Because those reserves are ultimately used. That money is ultimately used for something. And if that money is not there for 6 months, a year and a half, I think the absence of those funds will be felt more by some condominiums in our community than others, but I believe it will be felt. But that's not the only money that flows into the condominiums with a sale. In addition to that, you have move-in fees or elevator fees. I mean, in one of the buildings, the elevator fee, move-in fee is $300. It varies from building to building, but that is revenue that does come in with every new buyer. And if the buyers stop, that revenue stops. And another source of revenue that does come in, it's not huge, but it is there when a buyer is presented with the option of an in-unit maintenance, the one-time fee. Do you want in-unit maintenance? In certain buildings it might be 100, it might be 200, it varies from building to building. But again, that's additional money that comes into the individual condominium buildings with a new resident. So you have at least 3 different categories of income to the individual condominiums, and that spigot is about to be turned off for a period of time. So that the pain will be felt by sellers, the pain will be felt by condominium management, and of course the pain is also going to be felt by buyers who wanted to make Lansdowne Woods their home. And as many of you know who've been living here for as long as I have or longer, people move in here for it to be a forever home. And if those plans on moving here and making it a forever home, if that is on hold for a protracted period of time, some of those buyers are just going to go elsewhere in Northern Virginia or elsewhere in the United States, because the opportunity to make Lansdowne Woods their forever home will not be there at the moment in time that they're making that decision. So, yeah, there's a lawsuit, and I'm not going to get into the merits of it or mentioning the parties to it or how it may or may not resolve. That's not the purpose. The purpose is that people need to focus on what I'll call the downstream implications as the dominoes begin to fall of sales that do not happen and what sellers are going to do. My heart goes out to those sellers, particularly where the money is needed for assisted living. I don't have to tell you in the audience, assisted living is really, really expensive. And people in our community don't go to assisted living lightly. They go when there is a need. And often there is an intervention, like a family intervention. Members of the family say, Mom, Dad, you're falling, you can't really take care of yourself as you used to. So there is a financial and also a personal welfare imperative that drives that decision to sell. And I'm telling you, when that decision needs to happen and can't happen, those people will be among those who are the most seriously injured and aggrieved. And that's not to minimize those people who, for example, might want to go to Florida or might want to go to the mountains, because that's a real concern too. Another group that will be affected, but there's a workaround for them, will be heirs. Because as many of you know, if you moved into Lansdowne Woods for it to be a forever home, and if forever means forever, that you go out feet first. And almost always there are adult children who will be inheriting. And those adult children, look, it varies with your family, I understand, but if this doesn't apply to you, I know you've met neighbors for whom this does apply. The adult kids want their money. Mom and or dad are gone, and the adult heirs want to sell the place and get their money, and because they have lives too. For heirs, it would be easier for many of them to rent and to wait, true. But the downstream ramifications on heirs are still going to be there if and when prices decline after the resolution of this lawsuit. Remember, I didn't say settle, I said resolution of this lawsuit. If, as I believe will be the case, you have a near avalanche of sales all at once and prices decline, so that the value of the inheritance that the heirs were thinking they were going to get is similarly declining. This is a Houston we have a problem moment for Lansdowne Woods residents. And if anyone wants to speak to me privately about this, I can meet with you in the lobby of your building. If there are several of you in your building, I can meet with you in the party room of your building and go into more detail about what I've covered in this video. And I suppose if there's enough of a demand, I could rent a room in the clubhouse and bring in perhaps a real estate settlement attorney. I don't know what the ultimate feedback will be when people start to realize that what I'm speaking of this morning